What's up, everybody? And welcome into a video on Karen Reed, one of the most requested topics that we have had in our channel in quite some time. We thought the trial would have started by now. It hasn't, but some things are going on specifically with the trial. So we are going to break down in today's video whether or not they're going to change courtrooms, whether or not the Commonwealth, the prosecutors are doing things to violate Karen Reed's rights. There's been a lot of accusations of that, of cover ups, of people being in cahoots with each other. Is this another example of that in the courtroom that they've decided to try this case in? What alternatives could there be? What does the defense say about this? Are her rights being violated? And of course, answer your questions about that and give a quick update on where we are with jury selection and when we expect this trial to start. So go ahead and hit that like button if you guys haven't already. And make sure you subscribe to our page and hit that reminder bell so you don't miss any future videos when this trial eventually begins. So jury selection has been going on for some time and everybody's getting comfortable in the courtroom. And defense counsel noticed something wrong with the way the courtroom was set up with the jury box. And they brought it to the court's attention, asking to move some of the chairs from the jury box around so the jury would be able to see the witness straight on, watch their demeanor, judge their credibility. As we know in every trial, a big question is the credibility of witnesses, especially in trials like this, where you're going to have a lot of defense witnesses, a lot of prosecution witnesses that are saying two different things that at least the defense are going to accuse some witnesses of lying, I think, of having an agenda, of being part of a cover up. And when you're asking the jury to judge witness credibility and you're asking the jury to put together a very complicated case to try to find the truth, it's very important that they can not only listen to the witness testimony and hear it, but also see how the witness presents and see the witness's demeanor. And that's so important that it is included in a lot of our constitutional rights that we are going to get to today. But specifically, I wanted to focus on the affidavit that the defense attorney filed in order to explain the problematic nature and setup of the courtroom. I, David Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I am an attorney licensed to practice in Massachusetts since December 20, 1989. My office is Yannetti Law Firm. While selecting a jury and viewing the layout of the courtroom over the last several days, the defense became aware that once the jury is impaneled, what we estimate to be 6 jurors will be unable to view a witness's face while they are testifying. Attached here to as Exhibit A are photographs establishing that the current seating arrangement violates Ms. Reed's constitutional right to face-to-face confrontation. Ms. Reed has a state and federal constitutional right to face-to-face confrontation, which guarantees her right to have all members of the jury be in a position to see the face of the witness who testify against Ms. Reed in order to assess their demeanor and credibility. For these reasons, I am filing the foregoing motion in good faith on behalf of Ms. Reed and respectfully request this court reposition the jury box in a manner that allows all jurors to observe the witnesses who testify at trial against Ms. Reed. That is what they want. That's what they're asking for. Move the chairs around so the witnesses can see so the jury can see the witness and so the witness can see the jury, right? We've seen in trials how certain witnesses like to turn to the jury and talk to them. Sometimes it helps with the presentation. Sometimes it helps with engagement. Sometimes it helps with just them understanding what's going on in the case, especially if there's an expert and they need to be explained something that they might not know a lot about of. So some good questions are coming in already. Lisa said, so 6 of the 12 jurors are there only 6 jurors? So they are picking, I believe, somewhere between 16 and 20 jurors to sit on this jury. And the way that they're doing it is they were going to pick that many jurors in order to have some alternates. But there was an issue. I think the original number was 16 that they were trying to pick. And they got all the way up to 19. And people were thinking, why aren't we starting this trial? We have 19 jurors. We only needed 16. And the court seems to believe there might be some hardships or problems with some of the 19 jurors that they already have. So I believe they're still picking a jury today. They want to get to 20. And over the rest of the week, they want to whittle that down to the 16 And I believe we're planning on starting opening statements in this case on Monday. What would that be? April 29th or something? Near the end of April. This coming Monday is when they want to start this trial. So we will actually be getting into what is the evidence in this case. Not what have we heard about, not what are people saying online, not what are people saying on Twitter, not what people are saying on YouTube may or may not come in, not accusations being made, not other investigations going on, unless the court deems it relevant and reliable coming into the trial and in front of this jury. But as you can see by this picture, and I don't know if they put all of them in here. Yeah, so here's the view from seat number 9, where juror number 9 would sit 10, and they show all 6 pictures. And basically, you can see the back of the witness's head or the side of the witness's head, maybe the witness's ear, but not the eyes, mouth, face, body language from the front, and demeanor of the witness, which is incredibly important when we are discussing credibility of witnesses, what they're saying it, how they're saying it, and why it is such an important part of every trial that a jury does judge a witness's credibility. What gets me is I don't understand how this hasn't been brought up before. Noam said, didn't the defense go to the courthouse before? So sometimes you don't pick a jury where the jury's actually sitting in the jury box. Sometimes it's in the back of the courtroom. I'm not sure how they're doing it here. Maybe they thought from the angle you couldn't possibly have a courtroom set up where a juror couldn't see a witness. I know that would surprise me. But yes, I would have thought they might have seen it earlier than this. Maybe they felt like now was the right time since they're getting to the end of jury selection to bring it up. So I don't know what took so long, but better late than never. At least the jury's not seated yet and they can still make this decision. Okay. So let's jump to the state's response, or the Commonwealth, response here. See what they have to say about this. Let me bring this down so we can see this. All right. Now comes the Commonwealth and responds to the defendant's motion raising a perceived constitutional challenge to courtroom management issues regarding the location of seated jurors in relation to witnesses who are called to testify. Specifically, the defendant claims that the view of the jurors seated in seats 9, 10, 11, and 12 violates their constitutional right to confront witnesses. See Defendant's Exhibit A. The defendant's right of confrontation requires the physical presence of a witness testifying against him or her, the witness's testimony to be under oath, and the defendant's opportunity to cross-examine the witness. And because confrontation obviously means to confront the witness, the defendant has the right to confront the witness, but it also includes the jury's opportunity to observe the witness's demeanor. And that's how we get to this point. That's how we get to the question as to whether or not this affects or violates Karen Read's constitutional right. I would argue looking at the back of a witness's head does not give the jury the ability to judge and observe the witness's credibility and demeanor. So that begs the question. It's like, how is this a courtroom? How does a courtroom get set up like this? Is any other trial that was happening in this courtroom, is there an issue there where they're violating the defendant's constitutional rights? Has anybody ever brought it up before? Those are questions that all cross my mind. Let's see what else the Commonwealth has to say. The defendant challenges only the jury's opportunity to observe the witness's demeanor. Demeanor is defined as behavior towards others, outward manner, and includes more than facial expressions. So they could say you could get a witness's demeanor from the back of his head. I don't know. I think the fact that you wouldn't get to see their interaction with whoever's asking them questions and their facial expressions and their outward manner towards whoever's asking them questions would be important as well. Demeanor is any outward behavior. It's the way a witness stands or sits, the manner in which they speak, their body language, their tone of voice, and their verbal and physical responses to questions. Jurors seated in the 4 challenge seats can observe the behavior, demeanor, side profiles, or at least back, of a testifying witness's face, and are within approximately 4 to 6 feet from the witness stand. The Norfolk Superior Court was built in, 1827, and criminal trials have been conducted in the main session courtroom with substantially the same setup for over 100 years. The Norfolk Superior main session courtroom is also the largest courtroom in Norfolk County. So you would think that 100 years of history would mean this is not a problem. And while criminal defendants and somebody like myself might complain about it, it's worked and not been a problem or not been found by this court or higher courts to be a problematic setup. So then I guess we just roll forward, right? The Commonwealth's initial suggestion to satisfy the defendant's concern was to position the witness seat or instruct the witnesses to position their body to face the jury box while also remaining in view of the defendant. As long as a witness is physically present in the courtroom, the witness is not required to look at the defendant. Permissible for witnesses to sit at 45-degree angle from the defendant where the defendant could see the witness's profile and lips. Lips is an important one that the jury couldn't see from some of those pictures. Videotape testimony permissible where defendant could see witnesses by bending slightly. So repositioning yourself obviously is okay. So is that how they should solve the problem? Just change the chair so that the jury and the defense can see the witness's face, demeanor, lips, and judge the witness's credibility and expression. The defendant's motion indicates that Ms. Reed has already proposed an alternative seating arrangement, which would allow both Ms. Reed and all members of the jury the ability to observe the witness who testifies at trial. The suggestion posed by the defendant was to move jurors' chairs to the other end of the jury box. However, as explained by the court, the jury box contained 12 seats at the time of the suggestion, and whereas 16 jurors will be seated for this trial, that space would be occupied by the additional 4 seated jurors. So we're already going to have jurors in the spot where the defense proposed we move the jurors' seats. So that doesn't work. We have to come up with a different solution. The state has already suggested one, repositioning the witness chair or body so that everybody can see and judge their credibility. Given the defendant's objection, the Commonwealth offers another alternative, that the trial be conducted in Courtroom 25 of the Norfolk Superior Court. While a smaller courtroom, criminal trials are often conducted in Courtroom 25 as detailed in Attorney Yanetti's supplemental affidavit. He previously conducted a trial within this courtroom and during the trial had ample opportunity to observe the positioning of the box vis-a-vis the witness stand, as well as positioning of the witness stand vis-a-vis the defendant. I, Attorney Yanetti, observed that every member of the jury in that courtroom could clearly see the witness's face while testifying. I also observed that the witness was facing the defendant. See paragraph 8 of the supplemental affidavit of counsel in support of defendant Karen Reed's motion to enforce her constitutional right to face-to-face confrontation. So that was a supplemental affidavit that Attorney Yanetti gave in addition to the one that we read together. So we get the idea of where we're at, what the complaints are, and how we might be able to fix it. So my first question to you is, do you see a problem with the current setup based on the photos that we showed before of jurors only seeing the back of the witness's head? That's the first question I have. Chris K said, Peter, have you ever seen a courtroom layout like this? No, not specifically like this where they couldn't see the front of the jury. That's the most important thing, is that the defendant and the jury can see the front of the witnesses. I keep saying the front of the jury. The courtroom is 100 years old. I agree. I think that's a good argument for the Commonwealth. Azam said, Peter, why is it the Commonwealth, not the state? That's just how they do it in Boston. They keep some of the old traditions. I don't think there is anything, to my knowledge, that there's any difference between it being a state attorney, a district attorney, or the Commonwealth. I could be wrong about that. Obviously, I am not an expert in, what makes it the Commonwealth versus the state. It is not the Commonwealth here in Florida. Welcome to all the new members, some gifted by Rebecca and Chris K and Azam. Thank you guys for gifting memberships, and welcome Brian and Terry. And then we also have Rebecca gifting 10 more memberships. That's awesome. So it's a good time to mention that our members only live is going to be Friday, 10:30 a.m. I'm bringing Chase and JD on, my two associates, to answer questions about college, about law school, about the bar. They've done it pretty recently. A lot of you guys have questions about that. And just to get to know them a little bit more, they'll be featured on the podcast coming up, and they'll be working at our firm. And so I figured you guys would want to ask them questions and hang out with them for a little bit. And that'll be a really fun members only live for April. Tina, KS, Law Nerd, thank you for gifting 20 memberships. A bunch of new members will be here hopefully on Friday for the members only live. So I see a lot of questions in the chat as well about why have you not done more on this case? Why have we not talked about everything we know about this case? Is it a crime? Is it a cover up? And basically, let me take a second to share exactly what my knowledge is about this case. I know that the allegations are that Karen Reed hit her boyfriend with her car and left him to die. And I know that her allegation is other people have motive. They're connected with the cops and law enforcement. They committed this crime against her boyfriend and pinned it on Karen Reed. The defense is going to be a cover up, third party culprit defense. My client didn't do it. She is innocent, not just not guilty. It's going to be focused mostly on proving her innocence and that somebody else didn't do it as opposed to poking holes in the state's case. Yes, I know the defense doesn't have a burden of proof, but that's what it seems like in this situation. And the prosecutor seems like they're confident it's Karen Reed. They have evidence, based on, the damage done to the car, DNA, which the defense seems like is going to use that evidence as their theory. And it really is going to be a situation where both sides have completely different versions of how they explain the events and what the facts show. And the jury is really going to have to determine who done it. Very different than many other cases. Many other cases, there's one suspect. There's nobody else to really point the finger at. The state has all the evidence, and the defense is saying you can't prove it. Or we've seen some self-defense cases. We've seen some insanity defense cases, which are affirmative defenses saying, yeah, we committed those acts, but we didn't commit the crime for one number of reasons that we're calling out as an affirmative defense. I know there has been a lot of commotion around this case. Thank you, KNS, for gifting 5 memberships. I know there have been a lot of public accusations and other people getting involved. I know there's a federal investigation against the state attorney or the Commonwealth and the prosecuting attorneys. I know people are heavy on bandwagons of free Karen Reed or justice for John O'Keefe, thinking Karen Reed did it. I get all that. I've heard all that. I don't know anything more than that. I don't know anything more than the high level accusations and theories of the case from the Commonwealth and the defense. And I'm kind of glad about that because my guess is most potential jurors in Boston know what each side's going to argue. And if they don't know, they're going to find out in opening statements like that. But I don't think they should really know everything. I don't think they should know those details. And I don't want to be colored at all by any of that when I come in and I listen to the witness and I listen to the arguments. Now, what's bound to happen in a case like this is a lot of you guys, a lot of people out there are going to tell me, well, this didn't come in. And if you would have only heard this, then you would know. The same thing happened in Crumbly's cases with other hearings that happened and other things that happened in, even Ethan's hearings and how that might have affected the jury and the parents, the Crumbly parents case. But in reality, if the judge doesn't let it come in and the rules of evidence don't let it come in, then the jury can't consider it. And I'm not going to consider it in determining whether or not guilt was proven in the case. That may make people upset, and I understand that. But if it was really wrong and the judge screwed up and violated the defendant's rights, we hope that that defendant would win on appeal. Now, you only appeal a case when you lose, so it's very difficult to win. So I never want to get there and make that be the call. So we hope judges make the right call when evidence actually comes out appropriately. But in this scenario, we are going to focus on, in contract law, you focus on the 4 corners of the contract. So only what's written, not what you talked about before, not what you talked about after, not when you said wink, wink, but this is what we're going to put in writing. What you put in writing is what matters. And to me, in the 4 corners of the courtroom is kind of like the 4 corners of the contract in that whatever comes out at trial is going to determine guilt or innocence. That's what the jury's going to see. Hopefully, they're not going to know anything else that happens that is not admissible and reliable evidence. Because if that's what the case is decided on, that violates the criminal defendant's rights. Now, how is the federal investigation going to come in? How is it going to cross over in this trial? I have no idea. I'm looking forward to seeing that. It seems like we've got some higher profile attorneys on in this case, which will be interesting. I've heard some things about them from people that I've worked with and against them in the past. I'm interested to watch them in action myself. I love watching good lawyering, and that's potentially what we'll have in this case. Who knows? Julie said, just joining. I'd love your take on the videos the DA put out on YouTube. Seemed inappropriate to me. So I get it. In a lot of cases, I do this. A lot of cases, I look into all this stuff. But I was semi-late to joining this case, and so much had happened that I figured, you know what? Let's just do this case like we did Johnny Depp, having no clue what went on. You guys are like, oh, wait till you see the finger video, or wait till you see him screaming at her and slamming the cabinets video. And I didn't know what any of that was. And I watched it as it came out in trial in the context the lawyers and witnesses put it in front of the jury, the same way the jury learned those same facts. Queen Vega said, could you cover Derek Rosa / minor from Miami who killed his mom in her sleep? She had just given birth to a baby girl 2 weeks before. Oof, that is incredibly sad. I have not heard anything about that case at all. So how we pick the content on this channel, if you guys are new, is as many of you guys send it in, the more of you guys that have interest in it, that's what makes me take a look at it and break it down. And that's why we came to this Karen Read case, because so many of you all were saying, I need your opinion on Karen Read. What's going on, Karen Read? This is so wild. None of it's making sense. The evidence doesn't line up. Why is the prosecution being investigated by the feds? And I brought my dad on. We talked about the federal investigation, what that means, what it doesn't mean, what might come in a trial, what might not. So I encourage you to check out that playlist on our YouTube page if you want a deeper dive on that. But we're going in, eyes wide open, mind clear, fresh slate, clean slate. I could raise my hand, put my other hand on a Bible or right hand on a Bible, whatever is left hand on the Bible, and swear to say I could be a fair and impartial jury in this case. That's all I know. I don't really know which side, has more supporters on it. And I don't really care. I know the defense is going to have a defense. I know what it might be. That's not enough to get me struck as a fair and unbiased, as being a biased juror. I know what the state's theory obviously is going to be based on the charges. And that's it. Maybe the fact that I know the state's getting investigated by the feds might be too much, but that would be for the lawyers and the judge to decide. So I appreciate you guys sending me this. Continue to tag me and stuff that's going on in this case. Continue to follow along with any other videos we may bring out. This is probably going to be the last one before we do opening statement breakdowns and recaps of the trial and picking out the witnesses we want to talk about, focusing on the lawyering and what the judge does and what the evidence is and how the law is applied to that and how the jury might be looking at it. That's what we'll focus on. But I need you all for that, because your questions and your perspective, you could all be prospective jurors and potential jurors in the jurisdiction in which you live. So I love getting your perspective as we watch a trial together, because you'll let me know things I'm not thinking about, because I'm thinking about it as a lawyer, as somebody who knows exactly where lawyers are trying to go. Not always, but I can guess on where lawyers are trying to go. Questions have specific reasons behind them. Where's a lawyer going with this? When should they object? And you guys are like, that just didn't sound right to me. Or I didn't believe that witness for this reason. Or this witness is totally different, saying something totally different than what that witness is saying, and I just can't buy it at this point. So I love getting the information and thoughts and questions from you guys as prospective jurors, because it adds so much to the context and content of this channel. People are saying, get ready for the circus. This is unlike anything else you have seen. Well, as you guys know, most of the trials we cover are wild. And I say, this is not how it normally works. This is not what a normal trial looks like. It's absolutely wild. It's absolutely a circus. And it seems like this one is going to be right along those lines. So make sure you hit that like button. Make sure you're subscribed. Make sure your reminder bell is hit, and get ready to take this ride with me, because we're going to do it. We're going to check it out. We're going to follow it. We're also going to keep an eye on Chad Daybell's case. That trial is going on as well. I'm going to record a video to post tonight that breaks down what I thought was potentially the defense's best evidence to date and their best witness thus far for at least one of the charges for Chad Daybell. So I appreciate you guys so much for joining me, as always. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.